Hello and welcome to Outer Temple's Ask a Silk. Ask a Silk is a series where junior members of Chambers have a quick chat with a Silk at Chambers about a particular area of their expertise. Today I'm speaking to Eliot Woolf QC, who specialises in personal injury and clinical negligence, and that includes claims with an international element. And today we're going to be discussing those claims, and in particular I'm going to be asking Eliot about claims where the case is being heard in England or Wales, the applicable law is English law, but the claimant who has been seriously injured is domiciled, lives in another country, and what elements that brings into the considerations about how to plead loss and damage, any red flags or important points we need to think about. So thank you very much, Eliot, for joining me.
Not at all. Nice to see you.
See me as much as we've been seeing anyone these days.
Exactly. Good to have some human contact.
Well, the first thing, and probably the most obvious thing I think to ask you about for this kind of situation, and please do draw on any previous cases that you've had, is about the discount rate, really. Obviously, all the future losses that are being claimed are going to be adjusted by the discount rate to account for the fact that they're being received at the time of settlement or trial. What's the scope for deviating from the discount rate in a case like this?
I think probably the short answer is not a huge amount of scope for it. I mean, I suspect actually with the current discount rate set as it is at the moment, there isn't a great incentive.
Yeah.
And as you can imagine, the courts haven't exactly been encouraging parties to deviate. And but in principle, I suppose the door isn't firmly shut and bolted. I mean, I think under the renamed Section A12 of the Damages Act, the court does have power to apply a different rate if the party can show that it's more appropriate in the particular case to do so. But I think when the attempts have been made in the past, it hasn't been met with great success. And so certainly for the domestic claimants in Warriner in 2002 and Cook and United Bristol Healthcare in 2003, the courts sort of rather shut the door on that. But interestingly enough, back in 1999 and 2000, there were some Dutch claimants who had a good stab at trying to get the courts to apply a different discount rate with varying success because of the rather more stringent tax regime there. And so there was a case called Bichevel and Birrell in 1999 where actually the claimant was successful. And it resulted in the multiplier being increased by about 35%. And I think the judge did that on the basis of what was described as being the rather unusual burden of Netherlands taxation with not only income tax, but this sort of wealth tax. But unsurprisingly, the other side appealed, and the appeal was compromised. So I think there's quite a lot of feeling that it may well not have stood up on appeal. And in fact, actually, the following year, there was a case called Van Oudenhoven and Griffin Inns in 2000, where the claimant wasn't so lucky. I think in that particular case, I think the attempt was to try and sort of do an adjustment of about 7% of the multiplier because of the wealth tax. And the Court of Appeals said, no, there'd only be a sort of exceptional, there need to be exceptional grounds for deviating from the conventional rate. And just because the taxation was different wasn't enough in itself. And, the Court of Appeal said we'd need to have a look and see whether there are corresponding advantages in Holland, such as higher rates of return and, the level of indirect taxation or cost of living would be better there. So in short, theoretically possible, but you'd really need to have, I think, the very much right set of facts with a really punitive tax regime.
Yeah. It sounds like also it might be helpful if the country you're looking at has a similar system or method, if they happen to use something like a discount rate, because otherwise how can the court take all the factors and the methodology into account without sort of doing the Lord Chancellor's work?
Yes, I think certainly, I think in Warren the message was pretty clear that you'd have to be sort of putting something before the court which the Lord Chancellor hasn't taken into account in setting the discount rate here. And I think it's sort of quite hard to put on that. As I say, so taxation is a sort of obvious one to try and draw on, but I think easier said than done in practice.
Well, I suppose the next thing then to think about is when we turn usually to our Ogden tables, and we're looking at life expectancy, but that of course might vary in other jurisdictions. The Ogden tables are of course only based on UK data. So how receptive are the courts to arguments that a different life expectancy should be used, where the claimant's from another country and going to go back and live in that country when the case is over?
No, I think the courts will be very sort of open to that. I mean, as you know, the courts have always sort of long favoured a clinical over purely statistical assessment of life expectancy. But when the clinicians are making their assessments, they're often doing a sort of percentage reduction down from normal life expectancy. And I think we're sort of very used in the traumatic brain injury and spinal cord injury contexts for our experts to turn, for instance, to the Californian data provided by Strauss and Brooks, and then to make adjustments for UK life expectancy. And so if in fact actually the expert says, well, it would be a 33% reduction from normal life expectancy, then if there's good life expectancy data in another jurisdiction, then it makes sense for that percentage reduction to be applied to that jurisdiction's statistics rather than to our own.
Okay, right. So that's an avenue definitely you should be thinking about when you're looking at a different jurisdiction. I suppose then
this works out favourably for you, of course.
Yes, that's true. That's true. Always, as always. Well, depending on if you're for defendants, you can. That's again something to consider. I suppose then beyond kind of doing those calculations and using those base numbers that we're all used to dealing with, when the claimant returns to their country, when it comes to the care that's going to be required from a serious injury, which we know can often form a really extensive part of the claim, depending on the nature of the injury, how do we deal with care rates potentially being very different between countries? And have you ever encountered that before? Or do you find that you're able to deviate from spinal point 2 now, I suppose we're on?
Well, I think you need to have a very good expert on board. And I think that's probably the biggest challenge, is finding a sort of expert who really has a good understanding of, the different care regimes in different jurisdictions. So in fact, I did have a case not too long ago involving a claimant who was domiciled in India, and actually we had a really good expert who looked into and gave us advice on all of the sort of aids and equipment and care in that instance. And what was sort of interesting about it was, unsurprisingly, the care rates were much lower than we have here, but then there are other factors of it which are interesting. So for instance, the care expert made it clear to us that you actually wouldn't be able to get a carer to come for less than a 12-hour shift. That was the basic sort of minimum need. And so in a sense, what you sort of lost in your rate was made up for in terms of the hours, because the case I was looking at wasn't one which was particularly care heavy in terms of actual needs. So if it had been here, it would have been a few hours a day, but because of the 12-hour shift, it had a real sort of impact on the case. So yes, I think it's really sort of targeting the right expert who genuinely has knowledge of the care and adaptation or aids needs in a particular jurisdiction.
Okay, and then I imagine similar to that, when you're thinking about deductions that you're going to have to or give credit for, and the kinds of state benefits that are awarded overseas in the case of an injury, that might be something you'd have to get to grips with quite quickly. It's complicated enough here, but I'm sure you'd need to understand it in the alternative jurisdiction to make sure you're giving the right amount of credit, and certainly from a claimant's perspective, not too much credit, and able to sort of of calculate that going forward. So again, I imagine that requires some expert input.
Absolutely, and I suppose it'll either be from your care expert, or it might be an employment expert if you're looking at some incapacity benefits and the like. And it's again, varies from jurisdiction to jurisdiction. Good experts certainly crucial to that. And so, for instance, again, when I was looking at a case involving some Dutch claimants who had been injured over here, and then went back, they have a very sort of favourable incapacity regime there. And so our employment consultant let us know about the 100% provision in year one, right, which then went down to 75% of their previous salary. And common law principles are going to apply here. You're sort of Hodgkin trap, and you're going to have to give credit, unless in the particular regime there's a sort of recoupment. So obviously you want to avoid a double deduction.
Yeah.
And the other thing, of course, I suppose you need to sort of have a look at is, what are they just paying, a percentage of the previous salary? Most benefits are not being increased year on year as your salary would be increased, and so you still get a significant, deviation, a significant loss of earnings claim. But yes, you need to be very mindful of what the regime is and what benefits your claimant is receiving.
Okay, thank you. Then the last thing that comes to mind when thinking about these cases is currency. And I can see that this is where the claimant and the defendant are going to have different positions. But from your perspective, what currency should you be looking at for the court to make an award in, either for the final award or for something like a PPO?
Well, certainly in terms of the sort of final award, just for the conventional lump sum element, it's long sort of established that the court can award the damages in different currencies. And I think, obviously, as far as the court's concerned, the object is to award compensation which best sort of expresses the claimant's loss. And I think back in sort of 2007, Mr. Justice Lloyd Jones in the A.M. Powis Health Board was looking at a case involving an Irish domicile claimant who was, and he awarded the care and case management in euros there. And actually, fun enough, on the point of the sort of periodical payments which you were raising, what was interesting about that was that there was no corresponding sort of index in Ireland which would apply, and for that reason, I think Mr. Justice Lloyd Jones sort of made it very clear that it would be inappropriate to use an index which measures price inflation in the UK, and had no corresponding measure in Ireland. And in fact, actually, the claimant in that case elected, and the court agreed with the notion that it should be a conventional lump sum in that case rather than periodical payments. And actually, just sort of on the periodical payments point, the courts are quite willing to give the claimant permission to adduce evidence from an expert as to a suitable sort of wage index. And so I think in the sort of Mealing and Chelsea and Westminster Healthcare case in 2008, permission was given for the claimant to get expert dealing with sort of suitable wages in France. So yes, that can apply. Currency can also come into the PPO, and the PPO can be made, or logically should be made, if you're commissioning care and case management abroad in the currency which you're going to be paying the carers in, so that you can just mitigate the risks of sort of various currency fluctuations, I suppose.
Yes.
And yeah, be mindful of the tax regime there for PPOs as well.
Yes, absolutely. Well, yes, it certainly sounds like on each point, it's really a matter of making sure you've got that expert who's going to ensure that you haven't missed anything, and that there aren't any gaps for you to be falling through. But that's really helpful, and thank you very much.
Not at all.
Is there any lasting tip or thought you'd have to share with us on those cases?
As I say, I think the real thing is your sort of expert team as ever with these cases, and really having a good experts on board who can guide you through issues, whether it's PPOs, from an IFA, whether it's your employment expert helping you with the sort of state benefits and career projections and the like, and your care expert helping you with the regimes and the costs of commissioning all of your needs abroad.
Great. Well, thank you very much, Eliot, for your time, and thank you very much for watching. That's it for this session, but do stay tuned. We'll have many more to come.